In my discussions of the Supreme Court's decision in Louisiana v. Callais, I have mostly focused on the immediate impact on actual people and actual voters. The main impact of that decision is to allow southern states led by white conservatives to effectively obliterate the representation for black voters in their states, both in the federal government and at state governments if they choose to, under the idea that you cannot judge racial polarization and racial gerrymandering by partisan polarization and partisan gerrymandering, or put a little differently, according to the Supreme Court, the fact that in states like Alabama and Mississippi, the vast majority of black Americans vote for Democrats and the vast majority of white Americans vote for Republicans is incidental. It has nothing to say about the reality of racial polarization. That's just partisan polarization. And partisan gerrymandering, according to this court, is a legitimate aim of a state government. And thus, there's no real remedy. There's no claim to make under the Voting Rights Act when it comes to that kind of extreme partisan gerrymandering, which again amounts to racial gerrymandering. One aspect of the decision I haven't really spoken about is the extent to which it limits quite sharply the 15th Amendment to the Constitution. Now, the 15th Amendment is very straightforward. Section 1 says you can't restrict or curtail or abridge the right to vote on the basis of race, and Section 2 gives Congress the ability to enforce that amendment by all appropriate legislation. Louisiana v. Calais does two things to the 15th Amendment. The first is that it limits its scope. Now, nowhere in the 15th Amendment does it say that this is limited to intentional discrimination. And the Voting Rights Act was written and passed under the understanding that the 15th Amendment allows Congress to address discrimination in voting by any means they deem is appropriate. That's what the language says. In his opinion, Samuel Alito says that no, the 15th Amendment only deals with intentional discrimination. And because it only deals with intentional discrimination, the kind of inadvertent discrimination, you might say, resulting from extreme partisan gerrymandering doesn't count. One of the ironies of this is that in the moment the 15th Amendment was written, American politics in the South was starkly divided by race. There was a similar level of racial polarization. And in fact, the 15th Amendment was directly written to address racial discrimination in voting under the guise of partisan politics, under the guise of partisan polarization. Alito calls himself an originalist justice, but this is a very unoriginalist holding. It's imposing what he thinks ought to be the standards of the present on what the amendment was written to do. What Alito is really saying, in effect, that the 15th Amendment cannot remedy the things that the 15th Amendment was designed to remedy. It's quite absurd. But the other aspect of this is that Alito says that it's the Supreme Court that has the power to decide what constitutes appropriate legislation. He cites the court's decision in the 1997 case, City of Bern v. Flores, in which the Supreme Court then said that the court had the ability to define what appropriate legislation meant in the 14th Amendment. Section 5 gives Congress the ability to enforce the terms of the amendment by all appropriate legislation. Now, appropriate legislation, it should be clear, was a term used more or less to refer to the necessary and proper clause of Article 1 of the Constitution. And more importantly, the authors of both the 14th and 15th Amendment would have rejected the notion that the Supreme Court has the right to say what constitutes appropriate legislation. It was a major area of political contestation. In fact, in the 1860s, and 1870s, and 1880s, really throughout the 19th century, the idea that the court could even exercise what it called horizontal judgment, that it could invalidate the decisions of Congress, and that it had the ability to really decide the powers that Congress had. The view from many Congresspeople, and especially the Republicans who wrote the Reconstruction Amendments, was that this was nonsense, that Congress was a co-equal constitutional actor and had the right to say what the Constitution meant, and that the court's role was to enforce Congress's constitutional understanding, not substitute its own constitutional understanding for Congress's. The idea that the Supreme Court could determine what constitutes appropriate legislation for Congress's own authority to enforce the Constitution and to make legislation would have been anathema to the people who led Congress at the time and to people who wrote those amendments. I want to highlight this aspect of Louisiana v. Callais because it represents a massive expansion of judicial power. If the court is the one that can say what constitutes appropriate legislation, and if this is a court that takes an exceedingly narrow vision of what Congress is able to do, period, then what we're left with is a situation where, in a lot of ways, Congress effectively cannot enforce the Reconstruction Amendments. And in fact, on Tuesday evening, under cover of darkness, the court issued an order relating an Alabama case involving a factual finding of intentional discrimination in Alabama mapmaking. The court issued a per curiam ruling, unsigned, in the cover of darkness, saying that those discriminatory maps, again, that a court found twice, a district court found twice, were discriminatory, intentionally so. The Supreme Court said that those maps can stay up. The court said that you have to give a basically unbreakable presumption of good faith to state legislatures. It said that if a state legislature has an ostensibly neutral reason for doing so, you have to take that neutral reason at face value. And it said that racial polarization is not sufficient to prove discrimination when it comes to gerrymandering. It said, in fact, that racial polarization effectively doesn't exist. It's all just partisan polarization, and partisan gerrymandering is a legitimate aim of state governments. In this decision, then, the court almost made it impossible to prove intentional discrimination. If you can't look at polarization, if you can't look at effects, if the factual pattern uncovered by court doesn't count, then what is it can you look at? And mind you, the Alabama case wasn't even under the Voting Rights Act. It was under the Constitution. It was a finding of intentional discrimination violating the Equal Protection Clause. And the court says, fine by us. So according to the court, neither the 14th Amendment or the 15th Amendment can provide a remedy to voting discrimination in districting. The 15th Amendment can't cover non-intentional forms of discrimination, and intentional forms of discrimination are basically impossible to prove. If you want to sum everything up, what the court is saying is that a set of amendments written to protect Black Americans from voting discrimination restrain Congress from taking steps to protect Black Americans from voting discrimination. Louisiana v. Callais stands with the worst of the neo-Confederate rulings of the late 19th century. It stands with the civil rights cases. It stands with Crookshank. It stands with the Slaughterhouse cases. It stands with Plessy v. Ferguson. It is a ruling that, for all intents and purposes, nullifies the substance of the 14th and 15th Amendments in favor of an inert and toothless vision of colorblindness that really does nothing but allow people with power to subjugate those who don't have it.